the policies for the school districts, the authority of the employees, the procedure for class removal, disciplinary consequences and the opportunity to be heard, and then notice and consultation with the parent. And then the last piece is sort of this catch-all that the provisions of this act are not meant to supersede the suspension and expulsion requirements nor any federal law. And there's a laundry list of those. And so, Senator Rothfuss, do you want to add your comments now before I walk the bill?
Sure, Madam Chairman. Yeah, I appreciate the work of the working group. We did convene, as Ms. Heitrich noted, and basically started with the prior bill draft, which we heard concerns about. And even prior to that meeting, I asked all of the stakeholders that were engaged in the process to just send me notes of their concerns, things they liked about the bill, things they didn't like about the bill, and what their interests specifically were. And fortunately, those interests converged nicely. There weren't any clear and direct conflicts. So this bill draft is the result of that, with the drafting instructions going to Ms. Heitrich and integrated into the legislation. So this does actually capture what I think is pretty well a consensus position. That doesn't mean everybody got everything they wanted, but everyone was pretty comfortable in the end with where this is at. It does convey most of the interests that we discussed, with ensuring that the school districts still have the authority. We don't have a lot of explicit policy instructions. This is requiring that the districts have a policy, but providing for things that must be included in that policy. In other words, different areas and topics. And one of the key clear delineations, which there was a lot of muddiness around, was the idea of delineation between a classroom removal and a temporary classroom removal, where we were talking about those as if they were the same thing frequently, and they're obviously very different things. You send someone to the office, you're expecting them to come back at some point. You remove someone from the classroom, that's a pretty big deal, and you're going to have a whole process surrounding that. So one of the big changes, I think, from what we looked at last time was providing that clarity, and then having kind of clear responsibilities for the players in that process, as well as clear rights for the teachers to be engaged in the process and ensure that they're a part of the conversation. They might not have veto authority, but they're a part of the conversation. So I'm hopeful that the committee looks well upon this, and I really, again, appreciate all of the work of both Ms. Heitrich and the stakeholder group that came together to work on this.
Madam Chair, with that, I will walk the bill, and I would note at the outset, it looks very different from House Bill 65. I sort of rebuilt it from the ground up, sort of trying to, as I noted earlier, putting these items in sort of the larger categories for each paragraph. So with that, page 2, line 7 through page 3, line 14, this creates those definitions that Senator Rothfuss just mentioned for classroom removal, school district property, and temporary classroom referral. With regard to school district property, you'll recall that there was some discussion about transportation to and from events, and that was perhaps overlooked in the prior bill draft. And so you can see on the top of page 3 that has been accounted for. Moving on, page 3, line 16 through page 6, line 14, this is that sort of first category, which is the requirements for school district boards to adopt student discipline rules or policies, and those must include authorization of a school district employee to enforce those policies for those students that are under their supervision, establish procedures for temporary classroom referral and also classroom removals, establish procedures for identifying and responding to patterns of conduct that materially interfere with teaching or other students' opportunity to learn or the safe and orderly operations of the school, designate an individual, perhaps the principal, but someone to refer these disciplinary matters to. And with regard to that, I would say you'll note in that provision, let me find it specifically, it's at the top of page 5 on lines 1 through 6. It states for purposes of this subsection, designated official means the official designated pursuant to this paragraph. There are a number of provisions that follow where it identifies responsibilities for this individual. So just identifying that sort of at the outset. Establish early identification and behavioral supports for students engaging in violent, threatening, abusive, or safety risk conduct, or students subject to classroom removal 3 or more times, or classroom removal 3 or more times within 60 consecutive school days, or a lower threshold if that's identified by the school district. And then lastly, provide reasonable disciplinary measures related to the nature, seriousness, frequency, and circumstance of the conduct, and when appropriate, the student's age and developmental needs. So that brings us to sort of the second category, beginning on page 6, line 6 through page 7, line 14. These are the provisions that authorize the school district employees to take action. And those actions include removal of a student from the location of disruption when the conduct is violent, threatening, or physically dangerous. It creates a safety risk, or again, materially interferes with other students' opportunity to learn, or safe and orderly school operation. It also gives employees the authority to initiate a temporary classroom removal, requires assistance from administrators or other district personnel in carrying out these actions, and also authorizes referral of a student to the designated official for the disciplinary action or behavioral intervention. Moving on to page 7, line 16 through page 11, line 5. This is sort of the meat of the bill, and this is where a lot of discussion took place last year regarding the removal of a student and what that process looks like. And so it establishes a process for an immediate removal from the location of disruption. Does not by itself constitute a classroom removal. And temporary classroom removals are excluded from the designation of classroom removal. And I guess it's temporary classroom referral, not removal. I apologize, I misspoke. Again, the employee may request that the student not return to the assigned classroom pending administrative review. And back to that designated official, that person must review the circumstances and determine appropriate discipline or behavioral intervention after consultation with the employee that requested the removal. The initiating employee that requested the removal must receive written notice of the action taken. And if it differs substantially from the employee's recommendation, the reasons for that need to be identified in that correspondence. And then the student must continue receiving educational services during the removal. And the student may not return without a reentry plan being developed, and that needs to be as soon as practicably after the event, but in no instance no later than 2 school days after removal. The reentry plan must address the conduct, the discipline, the interventions, the parent contact, the employee input, the behavioral supports, safety measures, and a process or date for reviewing the plan's effectiveness. Moving on to page 11, line 7 through page 13, line 5. This is where the opportunity for hearing exists, and it authorizes disciplinary consequences as well. And those consequences can include alternative classroom or other supervised educational placement on school district property, in-school suspension and expulsion pursuant to the existing law requirements. And we've discussed that a number of times. There are specific due process provisions associated with those that reside in the preceding statutes. And then in the event that the alternative placement or it's an in-school suspension, the student must receive an informal opportunity to be heard unless the conduct is, so egregious that it would jeopardize the safety or otherwise impractical. And the opportunity to be heard is defined as well on the bottom of page 12, lines 15 through 20. And I think the important thing to note there is you're not entitled to a due process contested case hearing. You're entitled to be able to speak with the individual about your conduct and perhaps the consequences that are going to be imposed. And then moving on to the notice and consultation requirements, those begin on page 13, lines 17 through 14. And it specifies that written notice must be provided for any classroom removal. And this is where Senator Rothfuss was talking about the deviation and the policy choice, which is the parent and guardian have the ability to have a conference, but it's not an ultimate veto of the imposition of the disciplinary action. And then again, you have to identify what the conduct is, why the student's being removed, what actions are going to be taken to ensure that the parent is adequately informed. And then in the event that a parent is unable or unwilling to participate, it does not delay imposition of that school disciplinary plan. That brings us to page 14. Page 14, line 11 through page 15, line 2. There was a separate provision in the prior bill that required this as well, but it requires assistance for employees exercising authority under the bill. It protects them from adverse employment actions solely for solely for good faith use of the authorized disciplinary processes in accordance with the rest of this act. So basically, if you're acting in good faith, carrying out the provisions of this law, the school district is prohibited from taking adverse employment actions against you. Page 15, line 14 through page 16, line 2, this is that provision that I mentioned initially, where it states that it doesn't alter or supersede existing suspension and expulsion requirements. It doesn't supersede federal law, and it doesn't prevent districts from adopting procedures that are greater protections or additional requirements or more comprehensive disciplinary policies that are consistent with this law. Page 16, lines 14 through 15, this repeals the, let's see. Yep. Page 16, line, oh yes, so this is an interesting drafting item. If you note on page 16, lines 4 through 7, that language is stricken, but it's also repealed on page 6, line 15. And that's required because we're renumbering all of the paragraphs. So, and then lastly, on page 16, line 15, this repeals 214308B. That is the immunity for corporal punishment that we've discussed previously in prior meetings. Page 3, line 16 through page 17, line 15. These are requirements for the Department of Education to develop model policies, provide technical assistance, and identify regional behavior resources that might be available to the school districts in that area. Page 17, lines 17 through 19. This requires each school district to adopt policies or rules that are required by this act no later than August 1st of 2027. Section 5 on the bottom of page 15, or sorry, 17 on to 18 and then on to 19. There are various reporting requirements. So the school is required to report to the district. The district is required to report to the Department of Education, and the Department of Education is required to report to this committee. And in that last report, it also requires that the Department of Education evaluate the implementation of this act and identify any barriers encountered, how useful the reporting is, or any recommendations to change this act. And then finally, page 19, lines 14 through 17, this is the effective date, and it is effective immediately. So subject to the committee's questions, I know that was a lot of information very quickly.
Well, first of all, thank you, Ms. Heitrich. That 19 pages, that's a lot of work. And most of this was reviewed and revised and so on and so forth. So thank you for all your work. Questions? Senator Scott.
Madam Chairman, two questions. The first one, I don't know whether Tanya is appropriate to ask or not, but I will ask it because I want to find out before we're done. On page 3, line 17, we change the Board of Trustees may adopt to shall adopt. And my question is, are there any districts that do not now have such a policy? Trying to figure out how much difference this bill is making, Madam Chairman. And if there are some that don't, are they the smaller ones where creating a policy is perhaps more of a burden? That's the first question. The second one is on page 5, lines 11 through 13. There's a protection here that in the policy has to deal with a student that engaged in violent or threatening or abusive conduct or creating a safety risk. I'm specifically thinking of the instance where the student has a potential deadly weapon on them, not necessarily a firearm, but it could be, but because there are other weapons too, and you may want to take special precautions. Is that provision something that's really adequate to deal with what the school needs to do as a common sense emergency matter when they find a student with a weapon? So those are the two questions.
Hang on just a second while she's working on it. I think Senator Rolfes may have a question also or an answer.
Thank you, Madam Chairman. To those two questions, I think I can answer them. On the page 3, line 16 with the shall and looking at small districts, we can ask the School Boards Association, but my understanding is that every district has a policy that would be along these lines related to student discipline. I can't imagine any don't. With the shall, it kind of gets into what needs to be included in that policy, and they would not necessarily have included all of these aspects, which was the justification for the legislation providing kind of some minimum criteria. I think it's important to remember that it's not the maximum that can be included, but these are things that have to be components of that. So that's why the shall becomes necessary instead of the may, or there wouldn't need to be any changes to those policies. On the page 5, with regard to the deadly weapon, this is not the entirety, once again, of what would be available. We have other statute, certainly that provides additional authority for those types of concerns, and Ms. Heitrich can probably point to those specifically. And I'll just point out, we were very careful not to mess with those other statutes. So this is something that's being built over here while a lot of our more severe things are already handled in statute, and we're not messing with those intentionally. And I think Ms. Heitrich can point to those for you.
Ms. Heitrich, do you want to follow up?
Madam Chair, Senator Rothfuss, you're exactly right. If you take a look at 21-4-306, this is a suspension and expulsion. And the grounds include possession, use, transfer, carrying, or selling a deadly weapon as defined by Wyoming Statute 6-1-104A, Romanet 4, within any school bus, within any boundaries of real property, in grades K through 12. So there is a provision specifically for the situation that you articulated in the suspension and expulsion statutes.
Any follow-up on those? Very good. Senator Scott, go ahead.
Madam Chairman, I would want to make sure that this didn't unintentionally supersede some of those other statutes because it's more recently enacted. And I would have a question in some of our really rural schools where the kids actually drive to the schools, if they bring a weapon so they can go hunting on the way home, is that, how do you handle that?
Madam Chairman?
Then Ralph, let's go ahead.
So again, we don't touch that and we intentionally defer to it on page 13, the Romanet 3, and it even says it somewhere else, which I didn't find the other location, but it says nothing in this subsection shall be construed to alter or supersede any procedural requirement governing suspension or expulsion under 305 and 306. So we're pointedly deferring to those more severe circumstances. And that was by choice of the stakeholder group. We wanted to make sure that we weren't messing with that. As far as the gun in the back of the pickup truck concept, I don't remember how it landed honestly in statute right now because we had that conversation before. I'll say that this bill doesn't touch that in any way different from how it is now, but I remember that discussion from before, and I think we actually still prohibit. I think we landed on prohibition, but let's ask Ms. Heitrek.
Go ahead, Ms. Sitrek.
Madam Chair, Senator Rothfuss and Senator Scott, the definition for possession, use, transfer, carrying, or selling of a deadly weapon includes within the boundaries of real property used by the district primarily for the education of students in grades K through 12. I can't answer this definitively, but I suspect those are handled on a case-by-case basis. But that's probably a question. It is a question better posed to folks in the audience with firsthand knowledge.
Other questions from the committee? Yes, go ahead, Representative Kelly.
Thank you, Madam Chair. On page 6 at the bottom, on line 17, creates a safety risk to students. Somebody who studies politics all the time. Could we please get some clarity on what would constitute a safety risk or what would constitute even threatening? Because I've seen some precedent in other places where using the incorrect pronoun was considered threatening and a student can get in trouble. So from Wyoming statute and precedent, what's a safety risk?
I'm not sure which one of these co-pilots.
I'll
Okay, Senator
go on
Rothfuss,
that.
go ahead.
So a lot of this is intentionally not explicitly defined, and those are not, because this gets back into a school district and establishing rules, regulations. They don't call them that, whatever they call them for the school boards, which is slipping my mind right now.
Guidelines?
Thank you. Guidelines. They'll develop those and will call out exactly this. So leaving it to local control to decide what they want to qualify as threatening, violent, physically dangerous, safety risk, and those types of things. So they're going to have to include it, but that gives them the capacity to have that local control of the interpretation. And that's true of a lot of this. Again, that was something we were trying to make sure that we had all of the district have the right things as the overall structure, but trying to provide flexibility for them to work out exactly those types of problems based on their specific policy interests.
Yes, go ahead.
Yeah,
Ms. Heitrek.
Madam Chair, Representative Kelly, and generally, just legally speaking, you use a reasonable person standard. So for items like that, would a reasonable person in those circumstances believe that that conduct is creating a safety risk or is violent, threatening, or physically dangerous?
You're good? Okay, other questions, committee? I've got their bellies full, so you did a great job. Not too many questions.
Thank you, Tanya.
Yes, thank you. Thank you very much for your work on this. Probably WDE, we could probably hear from you guys first, and then we'll open it up for the general public. Welcome. How are you today?
Thank you, Madam Chair, committee members, Dickie Shaner, Department of Education. Superintendent Diggenfelder does not have a position on this bill right now, but wanted me to share that she appreciates the fact that this committee has retaken it up as a priority and also tried to address a lot of the input that we got on the last piece of legislation. It's been a priority for her to have this topic looked at because it was one of the priorities that came out of her teacher recruitment and retention task force. This was one of the top issues that teachers were talking about.
Questions for Mr. Shaner?
Madam Chair,
Yes, Go ahead, Senator.
Not a question, but that does raise a good point. So one of the challenges that we had previously was we kind of had two bills and they were coming at it from two different perspectives, where we had the educator approach that was one of the priorities of educators. And then we kind of had legislation coming at it that was more from the district side of things. And so a big part of what this bill did was bring those stakeholders together and try and get to the point where we were reflecting all of those interests and trying to find that middle ground. So I appreciate Dickie for pointing that out, that was one of the priorities that the educators brought, and they were certainly involved in this.
Other questions or comments with WDE? Do you see anything else that you'd like to add, or you think it's in good shape where it's at, or do you want to even make a comment on that?
Yeah, we're happy to, continue discussing it and helping along the way.
Okay, great. Super. If there's no other questions, the committee will go ahead and open it up for the public. Please come on up and tell us what you want us to know about this bill draft. Welcome back. Even though we've seen you once today, we probably still should have you introduce yourself as usual.
Thank you, Madam Chairman. I am Brian Farmer, Executive Director of Wyoming School Boards Association. And there's one specific element that I'd like to visit with you about a little bit, and it is the sheet that has been handed out to you as a potential amendment for you to consider to the legislation. Madam Chair, let me begin by saying I really appreciate the work of Senator Rothfuss with the stakeholder committee seeking to find common ground. I do believe that the bill represents a better version than what we had previously seen, and I appreciate that. I did have the opportunity to participate in that. And there's one sort of fine issue that I'd like to bring up, and just a bit on what you see in front of you as the draft proposed amendment. Now, this bill does go about amending 21-4-308. And on page 3, it begins with amending subsection A or section A of that. So in my draft amendment, I have the original language of subsection A, and I am not intending to go back to the original language. I'm fine with the amendment that you have in the draft of the bill. I just wanted to provide it for context, because the real change I'm looking at is to section B, which is then addressed on page 16. So all of this between page 3 and page 16 is chunking at what happens in A, and now we're jumping ahead to B. And B is both addressed on lines 4 through 7 where it is stricken, or in section 2 where it is repealed. So it's a doubly repealed, and maybe that double negative is a positive and you're leaving it in which case I don't know where we go. But nonetheless, I think what we want to do is we want to say, let's not be spanking kids. Let's not inflict pain or force for punishment, and agree with that. And so in what I have rewritten as a subsection B, providing clarity that the intent is to not use physical force as a means of punishment. So let's not do that. But there are other elements of B that are sort of a legal gray area. And that legal gray area has to do with an immunity that is offered to school district employees for the bodily touching of an individual in the administration of discipline. And so you might wonder, how do you get that out of corporal punishment? How does that mean a bodily touching during the administration of discipline? And I'll just tell you that lawyers are creative folks. And so we have seen real cases where somebody would say, hey, in the course of administering discipline, somebody grabbed a kid's arm while taking them to the office, or somebody got in between students to physically break up a fight, and perhaps there was injury or something along those lines in that happening. And when we take away this immunity that is here for a bodily touching in the course of the administration of discipline, we do lose a protection for the staff. And I think even if you don't believe me that you can construe corporal punishment to mean that, I think it's still worth thinking about what about the instance of that grabbing the kid by the arm to take him to the office or intervening in the fight and having a physical touching of the kid. I still believe that we want to have some protection for the staff member in doing that. And so what I have crafted as a section C then is really, and the words may not be perfect. You may need to fix that, or you may need LSO to dress it up a little bit to make it better. But the idea is that when we're talking about administering discipline, the process of administering discipline, not actual discipline itself, but that we want to protect the employee when they have that physical contact, when they're using physical guidance or some sort of restraint in order to maintain the educational environment, enforce safety, or manage student behavior. And so I would urge you to keep in a protection for the employees when engaging in the administration of discipline. Let's get the stuff out there about using spankings or pain as punishment. That's bad. Let's not have that, but let's keep immunity for staff who are engaged in the process of administering discipline. And so whether it is this or something like this, I urge you to consider that as amendment to your draft before you pass it. That's the comment I had specifically. I do want to address a couple of things that have come up in your conversation or discourse as a committee. I can say, Madam Chair, that all Wyoming school districts have some sort of regulation to address student discipline. Where that regulation lives might look a little different from school district to school district. Perhaps it is in something we call a policy. Perhaps it's in a rule, which are slightly different from a lawyerly sort of sense of how do you get to the regulation. Has to do with the due process offered in getting there. But nonetheless, everybody's got them. Some folks have it in a student handbook. Some folks have it in other places, but as Senator Rothfuss had pointed out, what subsection A does now, in addition to the requirement of having these policies, is it points out some specific things that must be in them once you have them. And so just to answer the question, yeah, everybody's got them. They might be in slightly different places, but everybody does have them. I think there was another question, but I can't remember what it was, so I will be open to questions that anybody has and happy to answer as I can.
Questions for Mr. Farmer? Go ahead, Senator Scott.
Chairman, my question is complying with this, if we pass it, is that going to be a burden on some of the smaller districts that maybe don't have the bureaucratic resources that the larger ones do?
Mr. Farmer?
Madam Chair, I don't believe that that would be the case. Wyoming School Boards Association does draft model policies. And so we have model policy of discipline that districts are able to utilize in crafting local policies. So that would be available to them. All Wyoming school districts do post their policies on the web. And so they can go and they can look at each other. They can see, if I'm a small district, what is another small district doing? What is a big district doing? And they are all available on the web. So those are available. The burden comes in being sure that we have sufficient time to pass policies, because anytime the policy is going to impact the rights of individuals, we want to make sure that there is sufficient opportunity for the public to comment on those. And then what we adopt must be substantially similar to what we advertise to the public. So if we change something, that adds time on, because now the public has to have new opportunity to comment. So I think the only burden is in potentially time frame, but I do appreciate August instead of July.
Other questions for Mr. Farmer? I have just one. Would we find most of the discipline policies that have been approved in school board policy, or that you say some of them are in student handbooks? Do people put most of them in their student handbooks, or do they do a combination of school board policy guidelines or staff guidelines, or what's your take on that?
Madam Chairman, I believe what you will find in policy for the most part will be the broad general guidance. When you get to specific discussion of conduct, a student code of conduct, that's more likely to be in a student handbook, and it's going to have more specific detail. Now, every student who matriculates in the school is going to get a copy of that handbook, either paper or electronic or whatever. But this says, hey, public, you can go to the website, you can look at the policy, and there's going to be certain things that will be in the policy. You will likely still have some things that are more articulated in a student handbook. And that may be where parents and kids and whatever look. I think that's the lens the school district comes at it from, is where are the users going to look for the guidance? And that's where we try to put it.
And lastly, just as a follow-up, did you feel like the dates that we have for when the Department of Education shall get these things, this policy matriculated, would those be reasonable? Are you guys good with those? On page 16 and 17, they basically talk about when the Department of Education has their policy for each district, and they amend it into this act, and then I think August 1st, 2027, each school has to adopt those policies. I just wondered if you were comfortable with those dates. And then it's another year before people have to come up with reports. So I just wondered if those were acceptable.
Madam Chair, so section 3 says department will have a policy June 1st of 2027. I will not presume to speak for the department of, I'm not planning any takeover of the department, so I assume they can answer for themselves. That seems reasonable to me. But the August 1st for the school district to adopt their policy, if this passes in March, we're going to be able to start work on it right away. It's always a struggle. There's always some districts that find it challenging to meet that. But you really do want to have something in place by the time school starts so that kids know the expectation. I think it's the most reasonable solution that we can shoot for.
Okay, thank you. Any other questions for Mr. Farmer? Okay, thank you for your testimony.
Thank you.
Mr. Mullen, go ahead.
Madam Chairwoman, members of the committee, Tate Mullen, Government Relations Director for the Wyoming Education Association. Without reading Mr. Farmer's proposed amendment in just the general idea of that, we are incredibly supportive of that. That is something that I know our membership has had issues with, whether it's breaking up a fight, the intervention, that piece, we have definitely seen that already arise. So incredibly supportive of that proposed amendment. The only other piece I had was I wanted to offer kudos to the committee. I am incredibly appreciative anytime it's an individual legislator or a committee, and you all have been very proactive this go around at reaching out and forming these working groups. I think that you can see that this is how we get to better legislation that doesn't take up so much time in committee meetings and then on the floor during the session. So this is incredible work when we actually proactively reach out, bring stakeholders in, get that input before a bill is drafted. So I would just commend that and ask you to please keep that up. So thank you. And with that, I'll stand for any questions.
Any questions for Mr. Mullen? Okay, they must have eaten a big meal because they're kind of quiet today. All right, thank you so much. Anyone else that would like to testify, please come forward on this bill. Welcome. Awesome. Please introduce yourself.
Hello, Madam Chair. My name is Fred Hollingshead, and I am the director of the Cowboy State Virtual Academy. At our last meeting, I testified on this bill, and I think I mentioned I really don't have a horse in this specific race. but just tried to raise some concerns that I had just as a school administrator in general. And first of all, I want to say thank you. I sort of feel like a lot of the concerns that I said, others had said, and those were heard and addressed. And I really don't have a lot to even say I think I would recommend changing. I did have one note at early on when you are defining or authorizing, let's see, I'm on page 4, line 8. Where we're authorizing school district employees to enforce district policies. I made a note. I wondered when we require school boards to create a policy, I wonder if it'd be worth it to require that policy to define at a minimum certified staff to enforce, without necessarily saying all district employees, but then allowing districts in a may to add other employees. You know, I think I mentioned before at the last meeting, we go through a lot of training from school law to, lots of different things when some of our staff members become certified staff. And I think we can certainly trust their judgment. We expect them to be highly educated, licensed professional educators. But not all staff members meet that bar. And I still think if we give districts the option to decide who can enforce, but at a minimum, to address the original issue that I had asked about previously, and we have been told, you've heard from many teachers. I certainly think mandating that teachers can enforce addresses that issue, but it also doesn't tie districts' hands. We may hire an 18-year-old kid that's mowing the lawns in the summer or something and see some, you know what I mean? Like I just think providing some leeway for districts still is an important thing, and we didn't quite get there maybe. And then the other thing, Mr. Farmer actually brought up corporal punishment. Earlier, you heard from Dr. Jeff Jones, our superintendent in Sheridan 1. And if he had to leave to go back for a board meeting this evening, and he did not ask me to say this, but I bet he would have been up here talking about corporal punishment. He actually did his dissertation on it back in 22, 23. I don't remember. It's his dissertation, but I know that in that work that he did, he surveyed principals across the state. And I think his research showed that 90% of administrators in the state were for removing corporal punishment. And I think there was even a movement in the legislative body, and I don't know which side, maybe both, that maybe didn't get all the way through at the time. But I would second what Mr. Farmer said. I think the immunity thing is important, but perhaps now is a great time to revisit that and remove the corporal punishment. I think there's plenty of support for that in our state. And we've got some recent research from one of your superintendents to support that. So, and I'll stand for
Oh,
questions.
sorry, I jumped the gun on you. Questions from Mr. Hollingshead? Oh, Senator Roth.
I was just going to note on that last point. So as the bill is drafted, it eliminates the corporal punishment through the repealer. There was the proposal of this amendment, which you may not have a draft for, which would still leave that eliminated, but it then restructures and provides the capacity for some protection, some legal protection against civil and criminal liability in the event that there's, these extraneous circumstances. So that is in there as the bill is drafted. I just wanted to make sure that that was clear.
Thank you.
Any other questions? Senator Scott?
Madam Chairman, as I understand, you deal with online virtual. It strikes me that there's potential for some unusual discipline problems there where somebody abuses computer, hacks things, gets into something they shouldn't, or otherwise is disruptive that way. Is there anything in here that obstructs your ability to deal with that kind of a problem?
Mr. Hollingshead?
Chairman Schuler, Senator Scott, thank you for that question. The answer bluntly is no. There's nothing in the bill as it's written that concerns me from the virtual side. But you're correct. We do have other issues that we may have to deal with. But frankly, the biggest concerns I think that we had were things about removing students from classroom environments and when can we get them back into those areas of learning. That none of that impacts me. If, my kids are being violent, they're being violent at home. They're throwing a chair in front of mom, not in front of our teachers. And so the other stuff with temporary classroom removal or referral, excuse me, I like the vocabulary change. While we may not remove them from a virtual classroom, but we have ways certainly to deal with any potential issues that we have discipline-wise. Thank you.
Any other questions? Okay, thank you for your testimony. Anyone else in the room that would like to testify on this bill?
Madam Chair,
Yes.
if I could just comment on one aspect that was mentioned, which is the certified teacher portion. If you look at page 4, lines 8 through 11, the last part of that phrase states that it's for employees for students under the employee's supervision. So the example of the landscaper wouldn't necessarily have children under his supervision.
Thank you for that clarification. All right. Go ahead, Mr. Christensen. Or did you have a follow-up to that? We'll let you go ahead and go then.
Okay, I'm
Even-
sorry.
even-
And I appreciate that. I read that as well. I shouldn't have walked away so quick, just in case there was follow-up. I thought about that as well, and I wondered if maybe defining what supervision means. If you're assigned to a teacher's classroom, I wasn't sure what that looked like, and so I didn't want to come up with an answer. But certainly defining what supervision means, because honestly, in the lunchroom, I mean, a food service staff member or a custodian, they may be adult supervision, in case something were to happen, but they're not necessarily assigned to that person. And so I thought maybe some clarification might be helpful.
Senator Rothfuss, yeah.
And on that specifically, this was one where we did have a decent bit of conversation of who it should apply to. And that was something that we talked about in the committee also. And we honestly left it this way to kind of leave it up to the school districts to figure that out and define internally, but making it clear that we're emphasizing that supervision aspect of it. So that's a little bit clear in statute, but again, provides pretty significant flexibility for a district to make that decision on the school lunch circumstance or something along those lines, how they want to define it. So again, I'd say it was intentionally vague. And I was trying to think through scenarios and as you were talking about it to see if we were missing anything there. So if we come up with something and it needs to be refined a little bit, that would be useful. But the hope is that the districts would be able to work that out in a little more detail without us being overly prescriptive.
Thank you. Go ahead, Mr. Christensen. Welcome back.
Thank you, Chairwoman Schuler. I want to join the others that have spoken already in commending the group in working on this bill. I think it's drastically better than it was when it left the budget session earlier this spring. There's one section in addition to the others that have been called out that I wanted to draw attention to, and that's near the end on page 18, paragraph B on that page. It still has, sorry, it's not there. I'm on the wrong page. I'll just speak of it generally. The bill still contains protections for teachers in terms of employment decisions made based on actions that may be taken with the permissions granted by this bill. And it's not comfortable, but there are people that enter the profession of education that find that they aren't necessarily good at educating. And one of the areas that comes out very quickly is classroom management. Mm-hmm. And I can foresee a situation where a teacher has very poor classroom management skills and their principal works with them to remediate those skills, work through and try to get to a point where that teacher can continue But we've seen many temporary classroom referrals, potentially some classroom removals from this teacher's classroom. And it's clear that the reason why is not to do with the kids. It's to do with that teacher doesn't have the skills to manage a classroom and teach well. Again, the vast majority of our teachers are consummate professionals and they're fantastic. And that's true even of those that have no classroom management skills. They just don't belong in the classroom anymore. And I would hate to get to a spot where we make it even more difficult to put the right person in front of our students that's going to be able to teach them well by a simple bill that's trying to help with classroom management. That'll stand for questions.
Yeah, I think, and correct me if I'm wrong, but I think page 14, the bottom of that page, 17 through 20 is probably the part you're talking about. And I'll let, there is one word here, I think, that kind of makes sense to me. Is it solely for making a good faith? But go ahead, I'll let you talk about it.
Well, Madam Chairman, we are on the same wavelength today because that was exactly what I was going to point to is the solely aspect. And your point is well taken, though. I understand that concern. And I was just reading through it to see if there was any easy way to clarify that. The solely is what a lot is then resting on. You'd have to be able to make that case that it's not because they, again, acted in good faith, consistent with district policy, which is what this is saying, that that's okay, but that they've shown a pattern of poor classroom management, and that would be the justification. And I don't know that that necessarily qualifies as an adverse employment action at that point either, but it may. That depends on how you characterize that. I don't have a simple good solution right now, and I don't know if you have any suggestions, but the point is well taken, and we don't want to do what you're saying. We don't want to get to the point where we're holding back inappropriate flexibility on ensuring that classroom management capacity is remediated in some way because of this. So thank you for that.
To your point, I'm not certain that I've got language ready for you.
Yeah.
We could have a further discussion.
Yep.
Sounds good. Any other questions for Mr. Christensen? Okay, thank you so much for your testimony. Anyone else in the room that would like to comment on this bill draft? Okay, we will go ahead and close public testimony. Okay, committee discussion. Well, I guess we better see if there's a motion here first. Yes,
Yeah, I'll move the bill.
okay, is there a second? Okay, it's been moved and seconded. Now we'll open it up for discussion. What are your thoughts, committee? Yes, go ahead, Senator.
Madam Chairman, I'd like to move the amendment that Mr. Farmer proposed doesn't affect subsection A that he's listing. That seems to be just for context, but I think that the way he's making an exception in his provision C for on the corporal punishment thing, I think that makes a lot of sense because this teachers and other school district employees will have to do some of these things that ought to be protected. Otherwise, I think we're putting the employees at risk and maybe preventing interventions that would prevent other students from being hurt. So I think that amendment is a good amendment. And I think it goes on page 16, but I think we ought to.
That's just what I was going to ask for clarification. Is it section 2?
Madam Chairman?
Is that where it belongs? Yeah, thank you. For
And I
that.
know we've got a second. I would ask the movement, instead of moving this as written, to move it somewhat conceptually to make sure that Ms. Hytrek can conform it in, because it can't be amended as it stands right now, but all of that language can be put in. So let's make sure that that flexibility is there
I would ask that you have a discretion to make it fit.
to make it work. All right.
Does that work for everyone?
In that case, then I support the motion.
Okay, all right. I don't even think that needs to be a friendly amendment. We're just going to do it conceptually. So
Yeah.
any other discussion on
Madam
this?
Chair.
We've got, excuse me. Oh, I'm sorry. Representative Kelly.
Thank you, Madam Chairwoman. I just want to say strong support for this amendment. As somebody who's worked in the classroom, has had to use significant force to stop a student from hurting himself by hitting his face up against a concrete wall. I'd hate to have anyone, I don't think any educator would ever stop to think about the law before trying to create safety in the classroom. And this is just really important that we don't want good deeds to go punished.
I agree. Any other discussion?
Madam Chair, one clarification.
Yes.
On the amendment, if you look at subsection C, what was formerly B as
Mhm.
rewritten, it states school employees in which each district. And so I'm just curious, does there need to be a qualification? Like, is it school district employees in each school district? And then just to note, that's a substantial policy shift, striking teachers, principals, and superintendents, and then moving to a larger category. And I don't know that that was highlighted.
Senator Rothfuss, did you have a comment on it?
Charlie moved it.
Well, I guess, yeah, it is Senator Scott's motion.
I didn't understand Patrick's comment, so.
You want to
Sure.
restate it? or I
I'll
will?
take another shot at it.
Okay.
If you look at subsection C and the striking of teachers, principals, and superintendents and replacing it with school employees in each district, should it be school district employees? And then just to highlight the policy shift from a larger category to all school district employees, which as it exists currently in law is teachers, principals, and superintendents. And I just wanted to make sure that the members of the committee were aware of that shift.
Representative Kelly, you have a comment on that?
Thank you, Madam Chair. I'm thinking about that language. If we change it to school district employees, then there may be independent contractors there for some reason who are not technically employees of the school district, which is why perhaps school employees in each district was used. I don't know. I'm not an attorney, but I have worked in a district as an employee of an outside organization.
Madam Chair and Representative Kelly, perhaps Mr. Farmer could return to the table and speak to the intent of that particular language. That might be helpful. Sorry,
Sure.
Brian.
And while he's approaching, I think, oh, go ahead.
Well, he's coming up, certainly my intention to make that category as broad as possible.
Yeah.
To cover everybody, and I thought the school employee language would cover everybody. Maybe you need to add people working, people otherwise present in the school district who are working contracted to the school district or something like that to cover everybody. But that's my intention, to cover them just as broadly as possible.
Mr. Farmer, do you have a comment on that?
Madam Chair, the language selected was intended simply to broaden the category.
Okay.
Right now, saying teachers, principals, and superintendents in each district doesn't say teachers, principals, and superintendents who are employees of each district in each district. So it was really just trying to broaden the category. Whatever the appropriate language that the LSO would feel appropriate, the simple intent is to broaden the category because more individuals than teachers, principals, and superintendents may be engaged in those behaviors. If we're looking at a paraprofessional who is breaking up a fight, if we're looking at a bus driver who is involved in the conduct, the intent was to have a broader category simply. I trust LSO can have the best language. So that's why I began by saying it may not be these words, but something like it.
Perfect. Senator Rothfuss?
Thanks, Madam Chairman. So when I look at the bill draft on page 4, this is on the Romanet 1, policies adopted under the subsection shall authorize school district employees to enforce district policies, et cetera, under the employee's supervision. And that's what governs the rest of the statute, is this concept of authorized school district employees, basically. So as we look here, it seems to me that it should be school district employees. When we contemplate Representative Kelly's concerns that there might be contractors, if those were direct contractors, if they were directly employed, they would be employees and they would be under state employment. If they were not, then candidly, the state should not indemnify them. They should have insurance that they're working through as a business in contract with the state of Wyoming and should be working through their own corporate insurance. So I think that changing it such that it's school district employees is consistent with Romanet 1. Mr. Farmer, what are your thoughts?
Mr. Farmer?
Madam Chair, I think the rest of the bill does use that language, so conforming language is probably appropriate. And Madam Chair, if I may, I think when you think about, say, a substitute or somebody like that, in that case, you still would have the employee-employer relationship.
Yeah.
The unique circumstance of a contractor is perhaps the only area, and from having done state contracts, there's always the indemnification requirement. And so, as Senator Rothfuss described, is likely how it would be handled. But it may be leaving a category open. I'm unsure of that. But consistency with the rest of the bill would be that language.
Thank you. So Ms. Hightrack, are you good with school district?
Yeah.
Being in
Madam
there,
Chair,
or should we
thank
just leave
you.
it?
I just wanted to make sure we had the intent correct. School employee would actually exclude superintendents, the bus driver, and those types of individuals. So that was the point, is what is the intent of who's to be covered? And I appreciate the clarification.
All right. So I think we're good with, aren't we?
Chairman,
Yes, Senator Scott?
lost me on the curve. A superintendent's not a school district employee?
School district, she said school employee.
School
Madam Chairman?
employee. Yeah, go ahead.
Yeah, Ms. Hytrick said school employee. A superintendent is not a school employee. They are a school district
District.
employee. So we need to make sure district is in there. Okay.
All right. Are we ready to go ahead and take a vote on this? All right, with the amendment as a place, no, we didn't say placeholder, but yeah, we kind of did. All those in favor of this amendment, please say aye. Aye. Those opposed, aye. Okay, I'm no. Oh, yeah, thank you. Forgot about people online, so. So basically that amendment has passed. Anything else in terms of amendments on this bill? Okay. We're ready to go ahead and take roll. Okay, I think we are. I see, but nobody's saying no. Ashley, are you still awake over there?
I'm ready for you, Madam
Please take
Chairman.
roll then, thank you.
Okay, so motion to sponsor 27 LSO 128 K-12 public school discipline as amended. Senator Brennan,
Aye.
Senator Olson,
Aye.
Senator Rothfuss, Senator Scott,
No.
Representative Bratton. She is no longer logged in.
Okay.
Would you like to excuse her?
Excused.
Okay. Representative Erickson,
Aye.
Representative Guggenmoss,
Aye.
Representative Kelly, Representative Lawley.
Aye.
Representative Singh. Representative Strock,
Aye.
Representative Williams,
Aye.
Co-Chairman Andrew. Chairwoman Schuler.
Aye,
That is 13 aye, 1 no.
thank you. That bill will move forward then. We're 2 for 3 now. We're moving right along here. All
Madam
right.
Chair, I just want to correct the record. I misspoke. It is 12 aye, 1 no, 1 excused.
Okay, thank you very much for that clarification. All right, the next bill for our consideration is, do you want to take a break, or it says a break in there? Do you need a break, or how are y'all feeling? Committee?
30 more minutes.
We can go some more? Okay, everybody's saying keep going. All right. So the next bill for our consideration is 27 LSO 0127, modification of charter school resources. I think Ms. Hightrack is up and Mr. Wilmarth. And as soon as you get here, take it away.
Madam Chair, members of the committee, Tanya Heitrick, Legislative Service Operations, and before you is 27 LSO 0127. This is a modification of the charter school resources. Recall at your last meeting, you directed LSO to make some modifications with regard to the calculations for the ADM and the resources provided to charter schools. And I'll turn the explanation of this bill draft over to Mr. Wilmarth. He also has a detailed memo within your packet as well.
Go ahead, Mr. Wilmarth. Welcome.
Great. Thank you, Madam Chairman, members of the committee, Matthew Wilmarth, LSO Budget and Fiscal Deputy Administrator. 27 LSO 127 Working Draft 0.4, as Ms. Heitrek explained, comes from recommendation, I believe, from the Wyoming State Authorizing Charter School Board at your June 1st and 2nd meeting to exclude charter schools from the computation of a district's average daily membership utilized in the education resource block grant model. Under current law, a school district ADM count within the funding model utilizes the greater of the prior year ADM or its 2-year average. The intent of this bill is to exclude charter schools ADMs from that computation for purposes of computing the resources through the K-12 funding model. So beginning on page 1, line 9, this goes into 21.3.314, which is the charter school section of Title 21. And it just makes some conforming amendments to broaden the specification of the reference statute that's going to be amended on page 4, lines 4 through, or page 4, line 4, page through page 5, line 3. That's really the meat of the bill and the amendment. In terms of applicability here, what does this do in terms of funding? That's really the cost or the impact. There are 5 school districts in the state that have charter schools. There are a total of 9 charter schools beginning in school year 2026-27. Of those 9 charter schools, 7 would be impacted by this bill because 2 of the charter schools, using school year 26-27 as the example, those 7 charter schools are operating in year 4 or greater. As you'll note on page 2 and 3 of the bill, there are some notwithstanding clauses for the ADM computation. For the first 3 years of a charter school, its enrollment account as of October 1st of the school year is the ADM utilized for the first 3 years of its operation. After year 3, it then utilizes, under this bill and under current law, the greater of the 3-year or the greater of the 2-year or prior year ADM computation. What this bill would do, again, is just remove the ADM from the charter schools from that district computation and specify that only to those charter schools operating. Of the 7 charter schools that this would impact, 6 would move from a 2-year average to the prior year ADM, meaning those 6 schools are growing. 1 charter school would not move to the prior year as its 2-year average ADM is greater than the prior year. As I indicated, the 2 other charter schools are in that first 3-year operation. So those schools are going to utilize its October 1st enrollment count. And then there's also 1 school that is in its 4th year of operation. So it'll use the prior year ADM, but it is also being adjusted for a grade expansion. So there's also a provision in the charter school statutes that allow a charter school to use the greater of the 2-year or the prior ADM, but also if it expands a grade or grades, that expansion of grades will occur in the year it occurs based upon its October 1st enrollment count. So nuts and bolts, what does this do? Under the projections using school year 2025-26 ADM as a proxy, it would increase the total ADM count through the block grant or the funding model by approximately 70 ADM. And it would cost approximately $575,000 each year. In your packet, you have a memo that specifies this is meeting material number 9-02. On the back of that, it specifies the charter schools and the district in which they operate. All of the districts that these charter schools are operating are utilizing the 2-year average. Those would remain under their 2-year average. So there is no ADM impact to those charter or to those districts that those charter schools operate in. And then you can see the only charter school that is anticipated to shift or remain at its 2-year average is Potter Academy in Laramie County School District number 1. It would remain utilizing its 2-year average. All the other charter schools that are in year 4 or greater would utilize its prior year ADM. And you can see the estimated impact on the far right column of what the increase in ADM for those schools would be. Finally, Madam Chair, just to reiterate, I know this is not in my memo, but I just want to make sure that the committee has a full understanding. Charter schools through the funding model receive funding no differently than the schools that are not charter schools in the funding model in terms of the formulas that are used to compute the resources. The differences within the first 3 years of operation and utilizing the October 1st enrollment as an ADM count as opposed to its actual prior year or 2-year ADM count. This bill does not alter those distribution of resources or anything like that. All the school level resources will remain to be distributed to the charter schools, and the charter schools would receive the district level resources in the proportional manner of the ADM for that charter school. With that, Madam Chair, I'm happy to take any questions from the committee.
Questions for Mr. Wilmer? Senator, go ahead.
Oh, I had some difficulty understanding the mechanics, what's going on here, Madam Chairman. So I want to ask some questions. It seems to me, in general, if a school's enrollment is declining, that the 2-year rolling average is designed to, as the 3-year one used to protect the funding of those schools, and that the prior year use as opposed to October 1 has the same effect. But if you're expanding, then as these charter schools are expanding, as I understand, I don't know about all of them, but the ones I know about are growing and growing fairly rapidly. I see you've allowed, the draft allows for that in part where they're adding a grade, but where they're expanding by adding additional classes in other grades, which is the case I know here, that isn't protected. That's you're going back to a prior year count, whereas an October 1st count would be a good deal higher. So I'm trying to get an understanding of what's going on here with a conventional school district, say that was in an area where the population was growing. Are they under the prior 2-year thing, or do they have a choice? How does that work?
Mr. Wilmer?
Yeah, Madam Chair, Senator Scott. What's occurring, let me just explain generally what's occurring, and I think what this is trying to solve, and I'll get to your more specific question on the individual districts. As you can see from the data, the 5 districts in which these 9 charter schools operate in, the 7 in which are not subject to the October 1st enrollment snapshot for the first 3 years of operation. Those districts in which those charter schools are operating in have a decline in enrollment on a district-wide basis. However, those charter schools are growing
So my understanding, the intent of this policy choice is to account for at a charter school level and capture if the charter school is growing, that they will be utilizing the prior year ADM, which is greater than the 2-year average, and allow the district to still have the soft landing of a 2-year average. Otherwise, under the current law, even though the charter school is growing, it is subject to the 2-year average because the total district ADM in that district is declining, and it overwhelms the increase from the charter school on an independent basis. To your more maybe specific question is what happens with the current chart or the current districts? Nothing. They will be held harmless or not held harmless. They'll have that soft landing of the 2-year average if they're declining. And if they're growing, they will receive their prior year ADM. In your case of a charter school or any school district that is growing in the current year, they will receive that additional funding for those increased students the following year. And that's no different than what would happen in the environment of a charter school. In the instance that they expand grades, the statute has been in place for 20 plus years to account for that October 1st enrollment count, to account for that expansion of grades, but not necessarily adding another second grade classroom if they've already had that second grade classroom. Madam Chair, there is one technical point on the bill, page 5, section 2. We didn't have the figures quite yet. And there is certainly a policy question for the committee too on this. The effective date in section 3 on page 5, line 17 is effective July 1st, 2027. The committee could certainly make this effective immediately to have this be in place for the 2026-27 school year. That is certainly not LSO's policy choice, or not our choice to make. So we left that blank for that consideration. The estimated cost using the 26-27 data is approximately $575,000. If you wanted to make this, or if the committee wanted to make this effective immediately, I would double that cost. But that's a policy choice of the committee. We just put in a placeholder of July 1st of 2027, which would be in effect for school year 2027-28, but entirely a choice of the committee and the legislature.
Senator Scott, did you have a follow-up?
Madam Chairman, I'm concerned here that the policy we've got has worked with going to the prior year for school districts where you have a relatively large enrollment that is growing typically relatively small, that the population doesn't change that fast usually. The charter schools, some of them are growing much faster than that. And I'm wondering if going to a prior year where they've been on October 1st is going to be a major problem. And I don't know quite enough about it. Maybe we'll have some people here that do know in that area. I don't know how much trouble we're getting into.
Madam Chair, Senator Scott, this has been the policy in place for 20 plus years. I think every district or every charter school that has been created is known kind of the rules of the game, or not that those rules can't be changed, but I think they plan those budgets and limit perhaps the growth of their schools to ensure that they have a predictable student count and budget going forward. But this has been in place for 20 plus years. But certainly, the one caution I would have is perhaps if you make one choice for charter schools in terms of a consistent current year adjustment, you may want to look at doing that for all school districts.
Other questions? I have just one. What was the school that actually had a great expansion? I assume that they must have had enough kids that they had to add a 4th grade or a 5th grade or whatever. What district was that in, or what charter school was that in?
Yeah, Madam Chair, if you look in Natrona County School District number 1, the Wyoming Classical Academy is continuing to grow 1 grade each year. I think that's their plan. The same is true for Cheyenne Classical Academy. I believe the Wyoming Classical Academy is either a K-8 or a K-9 this school year. I have to go back and look. I don't know if their plan is to go for a K-12 or not. But if that's the case, they would be adjusted. If they grow 1 grade each year, they would have that adjustment on an annual basis until they reach their full K-12 configuration.
Yes, go ahead, Senator.
The one in Casper, I know is growing a grade a year, but that's a minor part of the growth that is dwarfed by the growth in enrollment in the earlier grades that they already have. In some cases, they're doubling or more the number of classrooms they have there. And the rapidity of the growth scaring me just a little as to we could force them to strain that growth, which I suppose would force more students to stay in the current school district, which has its problems. And I don't want to do that. So I'm looking for a solution.
Senator Olson, go ahead.
Just to your question, Cheyenne Classical Academy is a K through 7. So similar to Wyoming Classical, it's adding 1 grade per year. So 7th grade was just added for this new year. So very similar type of growth model.
And just out of curiosity, Mr. Wilmarth, I mean, we know that the public schools, we're going to be in decline anyway, with or without charter schools. That's just the way we're headed right now because we have families that are leaving Wyoming and we just aren't having kids. A lot of our young people are, or if they are, they're having 1 or 2 instead of a generation ago where they were having 3 or 4 or 5. So we knew that our public schools would see a decline to some degree. I guess I'm wondering, do you have any data to show if there is a correlation between the places we're having declining enrollment in the public schools? Do they go directly to that? Or is it because we're just losing enrollment? Are they going directly to a charter or any idea on that? Or is there any correlation? Just out of curiosity. You probably don't have that data, but.
Well, Madam Chairman, we can certainly ask the Department of Education to see how many of the students enrolled in a charter school had previous public school enrollments. But as I indicated in the data, the 5 school districts in which these charter schools are operating are all utilizing the 2-year average ADM count. So all of these districts that these charter schools are operating on a district-wide basis are still seeing a decline in enrollment on a district basis. So I don't know that I would indicate that the charter schools are removing those students from the other schools within the district. It may have kind of a combined impact, but overall the state is decreasing about 2%. I think it was about a 2% decrease in enrollments this past school year. We're just over 84,000 ADM. So the trajectory has shifted.
Yeah, we were a high of 92,000, I think, at one time, weren't we? So yeah, we have declined.
Yeah, Madam Chair, you're
We need
correct.
people to move to Wyoming. Hurry, quick. We need your money. Thank you for that, though. Other comments? Yes, I almost called you Senator Lawley. Representative Lawley.
Thank you, Madam Chairman. And I'm not sure if I missed this, but the calculated number, if we kept it at the same date of July 1st, 2027. I saw the memo, there's some numbers in there, but could you clarify what that number would be?
Mr. Wilmarth?
Yeah, Madam Chairman, Representative Lawley, if you keep the July 1st date, the estimated impact is approximately the $575,000.
That's what I thought in the memo. Okay, thank you.
Unfortunately, if I just presume flat enrollment, the impact is 0. So I have to utilize last year's ADM and this year's funding model ADM using the prior 2 years to estimate the impact. My presumption is just double the number if you make this effective for school year 2026-27, which would be an effective immediate date. But again, that's a policy choice.
Thank you.
Other questions, committee? Okay. Sidetrack, anything else? Okay, thank you for all the information. All right. Well, let's go ahead and open it up. I think we have some of the folks from the charter group here, or does the WD want to chime in on this? Okay. The charter school folks want to come up first, give you a chance to lead us off. We do have 3 chairs. Yeah, jump in here. Let's fill them up. Welcome. Please introduce yourself. This is your first chance to say hi. So everybody online might not know you like we do.
Chairman Schuler, excuse me. My name is Fred Von Ahrens. By way of background, I was a member of Governor's Ride Initiative and currently a member of the State Board of Education, as well as the chair of the State Charter School Authorization Board. As with you and the Joint Committee, I want all students to thrive and be successful as they grow and live their lives. Our focus today and tomorrow is on what I'll call startup charter schools. The successes we've experienced over the last 3 years and also the challenges. What is working, and in many cases, working well, and the challenges that we feel are needed to be addressed so that the schools and the students within those schools thrive. Board member Janine Bateski will focus on this, and Executive Director John Waller is with us as well. Thank you.
Thank you. Welcome.
Well, thank you. And first of all, I want to thank you for all the hard work that went into this piece of legislation that's before us. As Fred has mentioned, we finished year 3 for some of our charters. And what we're seeing is that the citizens of Wyoming are really showing support for school of choice. The enrollments in these charter schools is going up. It's not the intent of these schools is not to replace the traditional K-12 system, but rather to complement it with other options. And I'd also like to know that these charters have also attracted students from the homeschool community. So some of that growth is not pulling from the traditional K-12 schools. As I've said to you in the past, the application process is time-consuming and expensive for applicants. Application approval happens approximately 18 months before school opening. The school does not receive any funding until the doors are open to students. These schools are started with passion and dreams. And it's just, I have to tell you, to sit there and listen to these folks as we go through the application process is just exciting. I mean, the passion and the drive they have to try and meet and provide unique needs is absolutely wonderful. Therefore, we're supporting this bill draft and would like to see it include an ongoing actual number taken on October 1st. The research that we've done, and one of the service providers for 3 of our schools, which has a lot of experience in several states around the country, says charter schools generally are funded based on the prior year enrollment with an adjustment in October. If the enrollment goes up, their funding goes up. If their enrollment goes down, their funding goes down. There's no soft landing. Their job is to attract and retain students. And if they can't do that, then it's only fair that they're not, that the funding goes down. But it also needs to be fair that the students that are in the seats are adequately funded. Headmasters are hired at least 12 months out from the opening of the school, and the school is operating on 0 funding from the state at that time. When the doors open, the schools have no reserves and generally have had to fundraise to support hiring the headmaster, stocking educational materials, and getting the facility ready to open. Charters have no upfront protections. Being funded on their current ADM count is the only safety net they have. And as you recall, and Senator Rothfuss, we've had this discussion before because in the past, we used to fund, and I always thought, well, this is kind of crazy, but once you actually live and walk in their shoes, you see why initially we were funding the first year for 2 years. The spirit of charter schools across the country is like running a business. They are funded based on the number of students they educate annually. Using prior year as the current baseline, enrollment counts, or ADM as we call it, are rebased early into the school year based on student counts. If the student count increases, as I mentioned, funding is increased accordingly. If the student count drops, funding drops accordingly. Like I said, no soft landing, no two-year average. And as I stated, there's no safety net. The only safety net is their ability to attract and retain students. So in addition to where we stand with the bill as it sits, we would like you to think about what I've just suggested in terms of let's fund them for the students that they're educating every year. And what we're seeing is, it's interesting to watch the trajectory, is I take Alpine as an example. Alpine is going to start off with, last week it was 73. I'm not sure what the number is today. We fully anticipate that number will go up. This year, I believe Cheyenne closed at 192. Their anticipated growth is somewhere in the neighborhood of 90 to 100 students. Wyoming Classical, their anticipated growth is somewhere between 50 and 70 students. So it's really, really difficult when you have no reserves to count on to pick up that many kids and have to wait another year until you receive the funds for those students. So I stand for any questions you might have.
Yes, go ahead, Mr. Aaron's.
Just one note, and Christian's here from Prairie View, but they actually had a program that they were going to go out and market for growth. And based on what they saw, they wouldn't be able to cover that cost, so they had to pull that marketing back.
Questions for Mrs. Bateski? Okay, thank you very much. Go ahead. Surely you've got something else to add there, John, right? Please introduce yourself.
No, John Waller, thank you, Madam Chair. John Waller, the Executive Director of the Wyoming Charter School Authorizing Board. I don't have anything to add. I really appreciate your consideration of this bill. This has been difficult for me because I see the success in these schools, and this year having to say, and a lot of you guys are going to get less money, because I feel like they're really meeting a need in Wyoming right now. And you know, from my experience, I came from Colorado, and when you put out a good product and parents are happy, that enrollment goes up, and we should celebrate that. And I want to support our schools as much as we can. So I would also stand for any questions you guys would have.
Questions for Mr. Waller? Okay, well, thank you. Appreciate it. All right, anyone else in the room who would like to come up and testify, please come forward. Welcome, everybody. I don't know who's going first. Want to start from the right or the left, or I guess whoever got here first probably should start. Go ahead, please introduce yourself.
Good afternoon, Madam Chairman, members of the committee. My name is Christian Winger. I'm the Chief Executive Officer of Prairie View School in Chugwater. I also really appreciate the work that has been done into this bill and the memo that Mr. Wilmarth put forward and the data that's in there. You can see my actual numbers that are in that. There's just a couple of things that I want to touch on to just really be able to give you guys the ground level data of what's actually happening in trying to grow a school. So in our first 3 years, we had to establish our special education program that wasn't funded until the very next year. Then we built a transportation program. I think I'm the only school, or we're the only school in Wyoming, charter school in Wyoming, that's running their own transportation program. So we had to fully fund that. That doesn't get reimbursed until the next year. So both of those major expenses had to come out of our general fund until they got caught up with the state. And so the enrollment piece is something that we've had on a 5-year plan of how do we continue to grow, how do we hire new staff. The school in Chugwater started off as a K through 12 school from the very beginning, so we're not expanding a grade every year. And so when we look at the coupling of the ADM between us and the district, it's unfortunate right now because, you know, my funding is essentially tied to a trend of what somebody else is doing. And interestingly enough, it hurt us this year, but last year it actually hurt Platte County School District number 1. Because last year our enrollment grew enough and theirs still continued to go down that it caused them to shift the other way. And so they had to take the prior year number instead of the 2-year rolling average. This year, it's the other way around. Their enrollment was still going down. Ours didn't go up enough that it caused everybody to switch into the 2-year rolling average. And so I'm being funded currently at 108 students when my last year's numbers were 126 students. So I'm getting less money this year than I got last year in my 4th year. And even though I'm going to have more students. So I really appreciate the proposal here in decoupling that because I think that's extremely important. But I also really want to reiterate what the Charter School Authorizing Board has suggested is that we continue with the October enrollment adjustment factor. Because our school is growing so much every year, I think it's really only fair that the school be funded at how many kids that we have. If my school had been here for 10 or 15 years, it might be a different conversation. Or if I was at my cap and my school wasn't growing, then it might not be that big a deal because my funding would level out and stay the same. But as Mr. Von Aaron said, our charter school authorized, or our board had a fairly comprehensive marketing program to get to 150 kids this year, which is what my cap is at. But when we realized we were only going to be funded at 108 kids, there was no way we could do it. I mean, we could pay for the marketing, but I couldn't hire the staff members that I was going to need to be able to continue to operate at that level. So we were facing a pretty significant deficit in our budget, being knocked back to that 108 kids instead of being paid out even at the previous year's enrollment of 126. So right now, I think we'll probably end up in around 135 kids for this upcoming year. So even if we don't have that October 1st adjustment factor, it's still probably going to leave me 9 or 10 kids short of being funded at. And then next year, if I hit 150 kids, it's going to be the same thing. You know, my funding is always lagging a year. And it's just so hard to try to stand these schools up and start these schools with the budget of, you know, building your special education program, building your transportation program, and then now being shifted into a model where I'm a year behind in my actual funding. It makes things incredibly difficult. So I would really appreciate your guys' consideration in saying, let's just get rid of let's decouple the district from the charter school, but let's also include that October 1st count and just keep it that way. So I'd be happy to answer any questions.
Questions for Mr. Winger? Just to follow up, public schools, that's when they have their cutoff, isn't it? October 1st? I think maybe Mr. Wilmarth would know that, or Ms. Hytrek. Just out of curiosity, I'm thinking that's when they finally, it seems like they have a number and then it cuts off at around October 1st. I just wonder if that's similar.
Madam Chairman, each school district reports an enrollment count as of October 1st. It's not really publicly reported until middle to end of December until the data is cleaned.
Okay.
So that's when then it is embedded into the funding model for those districts that are in the first 3 charter schools, that are under the first 3 years of operation or have the expanded grade. No district is given its October 1st enrollment count. And I guess that's the tension I kind of drew to Senator Scott's question is, if you choose to do, you have already made the policy choice for the first 3 years for charter schools. And in fact, you do it for the first year of operation. Districts are funded entirely on basically a prior year basis. So if you choose to, do this for charter schools, be cautious in terms of that policy choice, because there are districts that are continuing to grow. And if there's a disparity in how you do that on a long-term basis, Ms. Hytrek might have to be involved.
We don't want that as much as we like you. And even lawyers get involved, it gets kind of messy sometimes. So any other questions, Mr. Winger? Okay, thank you for your testimony. Go ahead.
Good afternoon, Madam Chairman, Carrie Klein with the Wyoming Public Charter School Association. And I won't go on and on about this. We stand in support of the bill. Do believe that it ensures that charter schools are funded based on their own enrollment trends rather than enrollment changes in the surrounding districts. I would also ask that you consider including language that has the ADM adjustment on October 1st to reflect the actual enrollment. We feel like that really ensures that charter schools are able to serve the students, the public school students that are in their building at that time. So again, just to be brief, we support this draft and ask that you consider the addition of that, the enrollment count piece. Any questions?
Questions for Ms. Klein? Okay, thank you very much. Who's next? Oh, wait. was
Hey,
there a
Madam
question?
Chair, just on that
Sorry.
point, enrollment is different than average daily membership, ADM. Enrollment is a count on a certain day. I'm not saying any charter school or district would do this, but there are some states that do fund on an enrollment count on a certain day. And sometimes they incentivize students to show up on that day. Average daily membership accounts for students enrolled throughout the entire school year. So if a student is enrolled in one half of the school year, they're a half ADM. So when we look at ADM, generally across the state of Wyoming, it varies by year, but it's about 98 to 98.5% of the enrollment count on October 1st, meaning there are a total of less ADM than enrollment. And so there is a difference between those two counts. One counts for all of those students who come into that school district the entire school year. There may be an instance where a charter school has more students show up in January as opposed to October. And they wouldn't be counted in that instance. And so I just, there's caution on both sides of that coin. And so I just wanted to draw a distinction between those two counts.
Thank you. Other questions? Okay, you got off the hook pretty easy. Welcome. Please introduce yourself.
Hello, my name is Ryan Reeves. I am the Chief Operating Officer of Academica. We are a professional services company that provides back office support services of accounting, finance, payroll, legal, things of that nature to charter schools. I work with schools in the states of Nevada, Colorado, Idaho, Wyoming, and Arizona. Based out of Nevada. My apologies for that. We can't all live in the states as beautiful and nice as Wyoming all the time. However, one of the roles that I do serve in Nevada is due to the number of schools and services that we provide there and the number of charter schools there, I have been appointed to the Commission on School Funding in that state. And as part of my role there, we examine school funding every year and try to determine what's the best adjustments to be made. And one thing that I've learned about the 50 states is that there are 50 different ways of funding public schools. So no one's found the perfect way yet. We're all still looking. With that in mind, and recognizing that there's no exactly right answer, I do want to say I am in support of this bill. I do believe that it's a great first step, I guess is what I would say. The step of separating charter school counts from district counts makes sense for the districts, as has already been shared, as well as for the charter schools, and provides a more accurate count. I would also agree that just to explain a little bit more of the realities that we're facing in the future, as charter schools grow out, their top grade levels are usually their smallest enrollment because it was a brand new school that had a very few number of students. And so even when you stop adding grade levels, just rolling out to your full standard enrollment that your building is meant to hold is going to result in growth in enrollment. And we want those students to receive proper funding, proper staffing, proper services of the great education that they deserve. And since we've already seen that you can do October 1 counts and fund on those for the given year, as is done for the first 3 years, it would certainly be beneficial, we believe, to the students to continue that in future years, and would agree that what's good for the goose is good for the gander if it benefits a district as well. Obviously, district circumstances being different, that our birth rate is not what it used to be. And every single one of the states that I just listed is experiencing declines in enrollment right now. There is not one state that we serve that is growing in overall public school enrollment. So, but Nevertheless, there will be times and migration between communities to where that would be beneficial. And we think that would be a great policy. And we would encourage that next step as well of adding an October 1 count into the future as an option to choose from between the 2-year, the average, the prior year, or the current year. Thank you.
Questions for Mr. Reeves? Okay, thank you so much for your testimony, everyone. Anyone else who would like to testify, please come forward. Any other takers? Okay. Going, gone. We'll go ahead and close public testimony. Hey, committee, if you're all still awake, you're still with me. That's what happens when you, oh, do we still have one more?
I have a question for you.
Oh, question. Okay, go ahead.
Madam Chairman and Mr. Chairman, do you want to carry this bill forward to the next meeting? Or do you want to deal with it right now? I'm prepared either way. There is an amendment or two I would propose if we do it right now, but what's your preference? How you want
You have a preference? Move forward. Okay. Yeah, that's where I'm at too. So I think if the committee's ready, Senator Scott, I think we could go ahead and if they want to make that motion to push forward, we can do that.
Madam Chairman, then I move the bill.
Okay.
And I would have a couple of amendments, Madam
Do we
Chairman.
have a second? Okay, we've got a second over there. Okay. It's been moved and we've got a second. So let's go ahead and have some discussion on the bill. Go ahead, Senator Scott, if you're ready.
Madam Chairman, what I would like to move is what Mr. Wilmarth described to us in terms of advancing the date a year so that we start with this fall. And that would also, and I think we don't need to wait for perfection in his amendment. I think if we can, in terms of the dollar amount, I think if we can take his estimate and if this passes, just double that and let the Appropriations Committee sort out what the real number needs to be at the time of the session when we know more. So, Madam Chairman, that's my motion.
Okay, just to clarify, so you're saying on page 5, the placeholder that we had there, you want to go ahead and add that number, the 575,000?
I want to add that number and I want to start it and start the increase with this current school year. So
Okay,
26 instead of 27.
I got you.
Yeah, make that effective immediately.
Effective immediately. Okay. Yeah, I was gonna say, do we have a second on that? Okay. So how about discussion on the amendment? Any discussion on the amendment? And Mr. Wilmarth, just to clarify, you said that would be basically if we go with that effective date immediately, that would double that.
Madam
That's
Chair,
correct.
that's correct. I would put a placeholder of $1,150,000 from the Public School Foundation Program account.
Okay. Other discussion on the amendment? Okay. Well, let's go ahead and take a vote. All those in favor of that amendment, Senator Scott, please say aye.
Aye.
All those opposed? No? Okay, that passes. Any other amendments on the bill? Yes, go ahead, Senator. I'm calling everybody senator today. Go ahead, Mr. Chairman. Mr. Co-Chairman. Yeah, not everybody can be a senator. You're right.
Thank you, Madam Chairwoman. I would propose a conceptual amendment that is maybe a workable compromise to dealing with this October count issue where they are running into a funding wall with the rapid growth of these new charter schools. I mean, currently the October count is on a 3-year schedule and then they stop getting it. I would propose moving that to a 7-year schedule so that we basically cover probably the bulk of that initial rapid growth phase to get them to the point where I don't know, they're probably pretty stable after about 7 years. And maybe to make that fair, maybe we would apply that to any new school district too. But I think that it would, just given the specific situation that they find themselves in, I hope that that might solve the issue.
Everyone understand that? Does anybody have a second, or do you want to talk second? Okay, we got a second. That's discussion on this amendment. Representative Lawley?
Thank you, Madam Chairman. I just need some clarification, partly just didn't hear exactly what you're doing. I think it's extending the second, third year out, but are you extending it out for a certain amount of time, or are we completely changing? And that's the part I didn't quite hear.
You want to restate that, Mr. Co-Chair?
Yes, thank you, Madam Chairwoman. Yes, basically making the 3 years 7 years. I think the 3 years is too short. The school is still getting established and people are enrolling at a rapid rate, and then everything falls off after that. But I think if you gave them 7 years, I think things would level out after that point.
Yes, discussion. Go ahead.
Yes, Madam Chairman, I have concerns with the proposed amendment, and I think the bill as it is right now, prior to the amendment, is in good shape. I think it's an appropriate step forward and good policy. And I'd certainly support that. Changing the October date and trying to find ways to extend that has a lot of other implications that I think are much bigger than this bill. In fact, I think that is a far bigger issue than what this bill addresses. This bill addresses something clear, concise, and I like the fact that it's a simple little standalone bill that will probably pass in 11 seconds, getting to the legislature. No problem at all. Putting an amendment on it that has significant implications. We don't know the budget that's associated with this proposal in any way. It's going to be a heck of a lot more than $1.15 million. I don't know what it's going to be. We can't know what it's going to be, right? Because it incorporates associated growth over several additional years. I have absolutely no idea. It's a much bigger bill. So it's one of those situations where we're amending in something gigantic into a nice little clean, friendly bill. I'd rather stick with what we've got here, take the win, get into the end zone easily, have a solution, rather than working through the concerns of the changed October date. Now, if that's something that the committee desires, that I think having another bill draft and working through it independently is appropriate. We don't have a lot of time, but we could try and get something to consider for next time if we wanted to work on the October date. But conflating the two issues, I don't know that I end up supporting the move to the October 1st date because of the implications that it has for the non-charter public schools in the state, right? 80+% probably of the students that are going into the charter schools, it's not 100%, but somewhere on the 80% area are coming from the public schools. So you're taking students from the public schools, you're expanding the charter school. We're paying the full cost of that student at the charter school. We're using a 2-year decline in the ADM at the public school. So you're effectively double paying for those students that you're taking out of the public schools. Well, the public schools now have to cut their staff associated with a dramatic increase. So we hear half the pitch here, Mr. Chairman, about the idea that these charter schools want to grow. And I understand that. I respect that. That's something that they should try and do. They want to provide exceptional public education. But for the most part, when they're growing, it means a decline in the other area local public schools that we haven't really talked about. And we would need to wrestle with that. So for all of those reasons, I think we should decouple these discussions. I think we should pass a clean bill that does what our existing charter schools really need to do. We need to decouple the 2-year ADM from the 1-year ADM and make sure that our charter schools get that top priority and that it doesn't become at risk due to this other much more complicated conversation that I don't know that I'm on board with.
Mr. Co-Chair?
Madam Co-Chair, I am in agreement, I guess, if we want to make this a second bill draft request instead of an amendment to the bill that we could maybe see in the October or November meeting. I think that's a friendly compromise here.
Would be good. Well, this is the third time I've been on the same wavelength with you because I was thinking the same thing. 7 years out was a little much for me, even though I understand the intent for that. But it was going to make me a little less willing to jump on board with everything else we've done with this bill. So I think that's a great idea to push that to a separate one, but we can even do that tomorrow if you want to think about that tonight and make that as a directive tomorrow. So any other discussion on the bill? Okay. That wasn't an official motion, was it? Or was it? It was an official motion, wasn't it? Or were you just?
Actually like formally made. it,
Okay,
but
you
I
didn't
think I
formally make that
discussed it.
motion.
I think we can move on. I think we're
Okay, all right,
okay.
we'll move on then. If it wasn't a formal motion, we will just move on. Anything else with the bill? Any other formal or informal motions on the bill? It doesn't look like I've got a question on the bill. All right, let's go ahead and take roll. Ashley, if you're ready.
Madam Chairman, this is a motion to sponsor 27 LSO 127, modification of charter school resources as amended. Senator Brennan.
Aye.
Senator Olson. Senator Rothfuss. Senator Scott. Representative Bratton is excused. Representative Erickson.
Aye.
Representative Guggenmoss.
Aye.
Representative Kelly.
Aye.
Representative Lawley.
Aye.
Representative Singh.
Aye.
Representative Strock.
Aye.
Representative Williams.
Aye.
Co-Chairman Andrew.
Aye.
Chairwoman Schuler.
Aye.
That is 13 aye, 1 excused.
Okay, the bill is passed. We'll move that forward. All right, good work. Is there anything else we need to do today? Is there anything else on tap? It just says recess. Is that kind of like go outside and play? Let's do it.
Let's celebrate
Thank-
recess.
Thanks so much, everybody, for today. We'll see you all back tomorrow at 8:30, or at least some of you. We hope to see you tomorrow at 8:30. We are adjourned.
Early.